Next up, David, there was a piece in the New Yorker by a Harvard law professor, Ginny Suck-Gerson, who, by the way, if you ever run across her name or anything she's written, it's worth it. She is like right and thoughtful and not a group thinker in any way of that term. You'll note, by the way, in that Rahimi domestic violence gun case that Judge Ho reposted, he cites a Jenny Suck piece as well, which is pretty cool. Anyway, she has this piece at the New Yorker called "The Secret Joke at the Heart of the Harvard Affirmative Action Case." And there's really two parts to this piece. One is the content of this, these documents, et cetera, that were sealed and that the public hadn't been able to see through the course of the Harvard Affirmative Action trial, the one that's now pending at the Supreme Court. But another equally fascinating part of this is the fact that any of this stuff was sealed from the public during the Harvard Affirmative Action trial. So I don't know. Do you want to start with the sealing or with the content?
Let's start with the content because it makes the sealing so much more interesting.
All right. So there's this, basically the head of admissions is talking to someone from the Office of Civil Rights at the Department of Education. The federal regulator has retired. He retired in 2014. This conversation is going on in 2012. And the DOE guy sends a parody email to the head of Harvard admissions making fun of the Harvard admissions office for discriminating against Asian students. And he basically has stolen the notepad from another Harvard admissions person so that he can write it on her, it like has her name on it. Like it'll say Harvard admissions memo of whomever. And the memo, and now I'm reading from this article, the memo denigrates, quote, Jose, who was the sole support of his family of 14 since his father, a Filipino farm worker, got run over by a tractor. It can't be that difficult on his part-time job as a senior cancer researcher. While he was California's Class AAA Player of the Year, with an offer from the Rams, we just don't need a 132-pound defensive lineman. I have to discount the Nobel Prize he received as well. After all, they gave one to Martin Luther King too. No doubt just another example of giving preference to minorities. The memo then dismisses the fictional applicant as just another AACJer, which is Harvard admissions shorthand for an Asian American applicant who intends to study biology and become a doctor. The joke here is this is an incredibly impressive kid. And then every single thing he does, they discount and find a way to say that it's not impressive because he's Asian. That's the joke. Ha ha ha. And the joke on the rest of us is that the judge seals this. It is still actually not, the judge has not made it public. She got her hands on this separately from her process of trying to get it unsealed in the court documents. Basically because she said it wasn't relevant to discrimination by Harvard admissions officers.
So not only not relevant, but sealed. So there's a lot of evidence. Yeah. There's a lot of evidence that a judge deems not worthy of admission into the case because of all of the various reasons why you object to hearsay, et cetera, more prejudicial than probative, et cetera. But then to affirmatively seal it, keeping it out of the public eye, is something else entirely. So I question that it's not admissible, Sarah. Like I'm really curious as to why it's not admissible, because it seems to be pretty probative of the notion that discrimination against outstanding Asian American candidates was so prevalent that it was a subject of a joke with a federal regulator. Like,
at the Office of Civil Rights, by the way. So let's just
yeah,
that's upsetting, but okay.
That's the chef's kiss part of it all.
Yeah.
And so
2012 Office of Civil Rights during the Obama administration thinks that it's a joke.
Yeah.
That they're discriminating against Asian kids. Cool.
And so well known that you don't have to explain the joke to anybody. Right. And so that's not A, admissible blows my mind. And then it was B, sealed, blows my mind as well. And, look, on this podcast, we very much give the benefit of the doubt to judges. We do not like to get into this assigning motives nonsense and all of that stuff. Look, judges speak through their reasoning, and we still believe that is the best way to discern a judge's motivation is their stated reasoning. This is stretching my benefit of the doubt.
Well, let me stretch it more.
Okay.
Because this actually was in the record. Harvard used an SAT score cutoff of 1310 for white students, 1350 for Asian American females, and 1380 for Asian American males if you lived in sparse country, meaning underrepresented states or areas of the country. As this piece notes, there were audible gasps in the courtroom when this evidence was revealed at trial. When asked on the stand why a white boy who scored 1310 would receive a recruitment letter while his Asian American male classmate who scored 1370 would not, the head of admissions said, among other things, that, quote, there are people who, let's say, for example, have only lived in the sparse country state for a year or two. And by contrast, there are people who have lived there for their entire lives under very different settings. I'm sorry, it's one of those, obviously, what? Are you serious? You're discriminating? You just assume all Asian people are recent immigrants? What?
I mean, and isn't that actually something you can discern from an application? Let's suppose you actually want people from, quote, sparse country, which, by the way, that phrase, sparse country.
I know, that's already insulting, but yeah, separately it's already insulting.
Yes. So let's say you want somebody who grew up in sparse country. Well, you know what? You can probably determine that, or at least ask that in an interview if someone grew up in sparse country, as opposed to saying, I'm just going to presume that an Asian person from rural Oklahoma just got there 6 months ago or whatever, a year or two ago. Yeah, I mean, you cannot in any way, shape, or form presume that. And this is something that I keep going back to when I'm talking to friends of mine who are very upset about the Harvard case. Is you just bring up a lot of this evidence and you say, is that okay? Well, no, that's not okay. What about this? Is this okay? Well, that's obviously not okay. Ascribing personality characteristics to people on the basis of race, for example, that's not okay. But there's a way to do race-based affirmative action that isn't like this. Okay, maybe. Really? Is there? Or is this inherently one of the problems of race-based affirmative action, is that unless you're tying it to specific past injustice, which, by the way, this race-based affirmative action is not tied to specific past injustice. This is diversity-based. The compelling governmental interest here isn't remedying past injustice, it's diversity. When you start to make decisions based on race stereotyping, this is where we end up. This is where you end up, and it's really, really ugly to see.
So just to follow this through then, the evidence itself of the joke was not permissible at trial because she thought it was unrelated to any evidence of discrimination by Harvard University admissions officers. As you said, David, that's questionable right up front of like,
yes.
Really? You think it's unrelated that they're having this back and forth email? Now, in fairness, the admissions officer in question was having lunch with the guy. And so his email back said basically, oh, I didn't know so-and-so had such a sense of humor, referring to the person whose name is on the top of the memo pad. And he's like, no, that's the joke. I stole her memo pad. And he's like, oh, we'll talk about it at lunch. So there's nothing in the emails from the admission side that is a red flag, except I didn't know she had such a sense of humor certainly implies that he got the joke. I don't think that'd be a very funny joke if it didn't ring true, right? Jokes that are the opposite, whatever. So there's it's unrelated to any evidence of discrimination, so we can't show it at trial. But then the sealing is actually because she thought that the joke was so, explosive, it would affect how the public saw the facts.
You think?
Yeah. So I liked this quote because I think it explains it well from an attorney, quote, familiar with the case, is how she sources this person. I think we can make some guesses there. Judge Burroughs mistakenly conflated admissibility under the rules with her own decision as the fact finder that this evidence would have no weight with her. Because remember, this wasn't a jury trial, it was her. So basically saying, I'm not going to weigh this evidence, so we won't include it at trial. And then, because it would have no weight with her, it would be sealed to prevent embarrassment to Harvard witnesses. Imagine, David, just slightly different facts, right? Imagine a company being accused of discriminating against its Black employees and that we're sealing evidence of potential discrimination because we don't want to embarrass that company for their blatant racial discrimination.
Well, it's so bad. Think about it like this. Imagine a company is discriminating against its Black employees. The discrimination is so obvious that the federal civil rights investigator who's looking into the company writes a memo joking about the discrimination, and then a judge says, nah.
Irrelevant. Yeah, not just that it's on the whole, it doesn't lean this way, it doesn't push me over the edge. It is so irrelevant, we won't even have it at trial.
Right. It's a remarkable revelation. It's a remarkable revelation. And good on Jeannie Suk Gerson. Like Professor Gerson is a Harvard employee, by the way.
And she sued to have this all unsealed, lost this part of the lawsuit. The judge referred to her as greedy for asking for it, which is outraging as well. And then she got it from another source. That's how we have this.
So I'm very down on Harvard for the way it has treated Asian American applicants. But bravo to Harvard's view of academic freedom.
Yes. Totally.
Because
absolutely, yes.
I can think of a lot of institutions that would absolutely torch a professor who did something like this.
She's a pretty famous professor there. She has a little bit more than just academic freedom protecting her and tenure.
True enough, but still.
And it's worth noting that because this wasn't part of the trial record, by keeping it out of the trial itself, forget sealing it, it is not part of the record that the Supreme Court justices can consider, which makes the timing of this New Yorker piece also noteworthy for this pod.
Intriguing. Yes.